a contempt proceeding pursuant to Rhode Island General Law 17-7-8 against Shawna Lawton, Jeffrey T. Britt, Matt Jerzyk, and Teresa Graham in connection with the board's efforts to obtain information concerning a campaign finance investigation. Mr. Marcuccio, would you
Sure.
introduce this, please?
Of course, Madam Chair. First, a procedural note. Originally, this matter was supposed to be one of only a few matters set for the agenda, which would have allowed us to have a full evidentiary hearing concerning the contempt proceeding. Given everything else that was put on the agenda, it was decided that we would first focus on the motions to dismiss that have been filed by 3 of the parties who are involved in the subpoenas. And we have, I think, I don't see Mr. Dodd yet. Is he here yet?
The letter that we received, they received the same as Mr. Verdecchia and I, noticed us to be here for 7. I happened to look at the agenda today and saw that it was a 5 o'clock agenda.
That, I guess that was before we changed the time that we would be scheduling it.
So I think they would probably be here at 7.
Mhm.
Or earlier, hopefully.
I'm sure they would, yes.
Unless somebody could contact him, because he may be at his office.
Should we do that, or?
I could take a moment and just, or one of the attorneys could call Mr. Dodd and
Okay, so we will table this for a moment, or?
well, we have 3 motions. We can either table it, or we could hear the other 2 attorneys while Mr. Dodd works his way here.
That makes
And then by the
sense.
time
Would
he's
you like that?
Yeah, please,
Makes sense.
Your Honor. I think we would prefer that.
But why don't we just take a moment so that one of the attorneys can reach out to Tim.
Very good.
Yeah, he had notice for 7, so he's going to head down now. So he said he should be here in about 20 minutes or so.
So should we proceed with?
That's up to the board. We could proceed with the other 2 parties and then proceed with Mr. Dodd.
Sounds right. You amenable to that, gentlemen?
Yes, please.
Or we can put you at the bottom of the calendar.
We think about that for a moment.
Do have the parties decided who would like to go first?
I'll go first. I think
Mr. Verdecchia?
historically I've always received first.
I think yours was filed first or before Mr. Heeman's.
In any event, I think we have a united front pretty much.
Counsel, could you
Tell us your name for
Yes,
the record.
John Verdecchia on behalf of Teresa Graham.
Nicholas Heeman on behalf of Jeffrey Britt.
Board members, respectfully, I have submitted a written
Could he
objection.
speak into the mic?
I have filed a written objection, relatively short. It's based on 2 grounds. One essentially is mootness. The other is a procedural objection to the effect that the board did not follow its own rules. So I don't think I need to expand too much more on that. The rule speaks for itself. I believe it's Section 8. If my recollection serves me correctly, I think when we were here for that particular hearing, I do not recall the executive director or a designee making a ruling on our motions, our collective motions quash, and that would seem to run counter to the rule.
Well, the board can designate somebody from the staff to hear it, is that right? Is that your understanding as well?
Well, it says designee. Truthfully, I don't know what that means. I don't know if that means the board collectively is a designee. I would think if that was the intention, that the rules would simply say that the board
If the board
do it on its own.
can designate someone to do so, the board itself could do so as well.
I don't know if I agree with that. It seems to me that the intent of the rule is more to have sort of a hearing officer type situation. I mean, that's my interpretation. That's been my experience in other forums and with other hearings. Because as I said, it would seem to be no need for the rule if, in fact, the board were simply going to make all the rulings, take all the evidence, so on and so forth. It would seem that.
But in this case, the staff itself issued the subpoena, so wouldn't it make sense, rather than to leave it with the staff to do so, to leave it with the board?
I don't have the subpoena in front of me. It's been a long time since I looked at it. I don't know who signed it. I thought it may have been signed by Mr. Raposa as executive director, but I don't remember. But in any event, obviously we may have a difference of opinion on that, but it seems to me that procedurally there may be an issue there. But I think the greater issue is the mootness issue. The case law seems to be pretty clear that once a matter is in fact terminated, that the need for a contempt citation or motion, or however you would like to categorize it, becomes superfluous, because at that point there is nothing to produce. There is the underlying basis for coercing compliance is no longer present. So it would seem that, the way I interpret the case law, that, and it's my understanding that the board had reached a resolution with the underlying investigation. I mean, obviously I wasn't made privy to that. That's anecdotal. It's my understanding from the various news outlets and speaking with other individuals. But
Mr. Burdecki, just on that point, isn't it also another purpose to vindicate the authority of the board? Isn't that outside of the purpose of coercing someone to provide discovery, there's also the dignity of the entity itself that can be the subject of a contempt proceeding. Isn't that right?
That's true. There are two separate bases for contempt. But without getting too hyper-technical, the notice that I received doesn't even mention the word contempt. I believe it says the parties are requested to be here for the purpose of discussing a resolution or how to proceed on the failure to comply with the 30-day order. So it isn't clear from the notice whether this board was proceeding on a criminal contempt basis or a civil contempt basis. And if this is a criminal contempt type of proceeding, then there are a host of other objections which I would make, because there are many different procedural requirements that have to be met before the board would be able to proceed on that basis. And I haven't seen that, quite honestly.
Do you concede that the board has that authority, or do you dispute that?
That's a good question. My recollection of the administrative code that gives the board contempt powers, I believe, and I'm speaking from memory, that it states something to the effect that the board has similar contempt powers as a court. I believe that's the language.
Interrupt, I'll give you
It's
the
actually-
language.
It's actually a statute, it's not
Right.
a
Okay.
regulation, and it says the same.
It
The
says
same
that
as a court.
the board is authorized to compel by its subpoena production of goods, documents, etc. And every person disobeying any subpoena shall be considered as in contempt, and the board may punish any contempt of its authority in like manner as contempt may be punished by any court. If you then look at the contempt statutes, the statutory authority for the courts, and particularly with respect to the district court, because that's where I wrote the book, there is a specific statute, Rhode Island General Laws 885, which says the court may punish any contempt of its authority by fine or imprisonment or both. So the statute gives us the same authority as the court, and the statute gives the court the authority to both proceed civilly and criminally. That's my interpretation.
And I think I would agree with that, and having said that, then I'm sure the board would also have to concede that if, in fact, you have the same powers as a district or superior court, that you must also follow their rules. And you must also,
You mean like Rule 42?
Rule 42 is one rule.
I mean, so setting aside that issue, because the board can always cure a notice by convening a contempt proceeding consistent with, as you were saying, Rule 42, but it seems that you do concede at least that it has that authority.
Yes. Yes. And again, not to get bogged down in hyper-technical procedural arguments, as I just previously stated, if the board is sitting in the position of a court vis-a-vis contempt, then I would submit that the board is bound by the case law as developed by our Supreme Court, as well as all of the rules of the Superior Court and the District Court. And if we are proceeding on a criminal contempt basis, I would submit that this proceeding up to this point is defective in that regard. So, again, the notice that we received was relatively vague. It did not distinguish or provide any detail as to what type of proceeding that this was. But if I could just maybe take a right-hand turn here, there's just something I would like to say to the board. And namely, that is, at the time we had filed our motions to quash, and then we had received the board's decision. Myself, Mr. Heeman, a couple of the other attorneys had sort of a meeting of the minds as to how we should proceed from that point with regard to appealing that decision. And with 4 attorneys meeting, I think we had 4 different opinions as to what the proper procedural mechanism was to do that. And the reason I bring this up is because I think it's important that the board understand that the non-compliance by my client was not based on a deliberate disrespect for the orders of this board. Quite the contrary. My client was relying on legal advice received from myself. So if anyone is to blame, I would submit it is me and not her. But again, I would like to emphasize to the board that we found ourselves, myself and the other attorneys, in sort of a legal quandary as to how to proceed at that point in order to protect our client's interests. And that was all we were concerned about. The subpoenas were relatively broad. They asked for quite a bit of personal information, private information, and we were very, very careful to make certain that we did not jeopardize those interests for our client. So the failure to comply up to this point, again, was not driven by any desire to thumb our noses at the board. Not at all.
If I could just ask a question about that. There was a 30-day order to produce. It was the result of the denial of the motion to quash. So you had the hearing on the motion to quash, then we set forth a pretty extensive briefing schedule. we obtained the documents that you provided concerning this matter. We had a hearing where we made the determination that we would deny the motion to quash the subpoena, and then the board entered a 30-day order for compliance. It seems to me that that's a final order, and it's clear to me that if that was your point, that if you thought you had a remedy in the Superior Court, then that was when you should have taken it. And by not taking that remedy to another court, to a court to determine whether or not we had acted in excess of our authority, you waived the right to contest the authority of the board to order the 30-day compliance. And so we had a 30-day compliance order, and everybody ignored it. Everybody took a 30-day compliance order issued legally by this board and just ignored it. Why would you do that?
Well, as I was trying to explain, Judge, it isn't quite that black and white and that simple, because to my knowledge, and we discussed this, I didn't see any direct appellate route to the Superior Court or the Supreme Court. We discussed various options. We, I think, collectively concluded that in order for us to have any standing in the Superior Court, we would need to have a justiciable issue before we could go there. And it seems to me that an open-ended order to produce without enforcement action being taken would probably be premature and would get us bounced out of the Superior Court. That was our thinking. Now, right or wrong, we can debate, but the point is, that was the mindset. It wasn't, we're just going to ignore them, we're just not going to comply. It was a difficult procedural decision to make, and we've discussed it at length.
If I can jump in just for
Sure.
a moment to get some further explanation on that route. Our thinking was it'd be a declaratory complaint for
I know
declaratory
that you
relief.
made that point. I think
And
you were-
the issue that we argued amongst ourselves is, did we have a sufficient case or controversy to warrant filing a declaratory judgment complaint? We could file it upon the 30-day order, or did we have to wait for a motion, or excuse me, a complaint notice in contempt to bring a higher level of gravity for the Superior Court to take interest in the matter? Then there's this interceding period of 6 months that goes by between the issuance of your order and then the resolution in April, and
I
what
think
brings us
our
today.
order was actually finalized in January, wasn't it? Because somebody was on vacation. Ray, do you remember this?
I think, I think that there were two sets, one of which was the Timothy Dodd matter,
Ours
which
was,
later.
I
Yours
think
was
our
earlier.
response was due
In
November
November.
13th or something.
Right, so
If I remember.
that was, so your response was due in February, and we took action in April.
I think our response, Your Honor, was due in November, as it pertains to the two of us. Mr. Jerzyk's response may have been due.
That's my
later
recollection,
on
is that it
in
would have
November.
been in that time frame, and then Tim Dodd was later because he was court excused when we had the first hearing.
So when we received the notice, we were going to file the declaratory judgment complaint in Superior Court and have it served prior to this hearing. But then when Mr. Marcuccio communicated to us that we would only be dealing with a motion to dismiss, we held off on that, because if the matter can be resolved, in a way that satisfies the board and satisfies the clients and protects the rights that we're concerned about, we would be open to that. But in light that it was limited only to the motion to dismiss, we've held off on any service of a complaint of that nature, because we did want the board to understand where we were coming from, where, you put 4 lawyers in a room, you get 4 different opinions, and that was our thinking, and why waste judicial resources and
Actually, I
bring
think you
this
get
all
5
to-
opinions
Right.
from 4 lawyers.
Right. So that was our, and as, again, we came to the hearing, we had a lengthy argument before you at the time, and it was not to thumb the nose at the board's authority, but rather we thought these were important issues that would need to be resolved at some point higher judicial authority than where we sit here. And if they said, no, you people are wrong, obviously we would proceed accordingly there. But we do think that these are important issues, and that our clients do have significant interest in preserving their rights and protecting their rights. But just to, not to interrupt John, but I just
No.
wanted to provide some additional context to his explanation.
Judge, just to clarify the record, according to the 30-day order that I have, it appears that the board convened on October 11th of 2017 and voted at that time to compel production by November 13th. So as Mr. Heeman stated, this goes back actually to the second week of November. So with that being said, Your Honor, I don't want to belabor the point, members of the board. I just want the board to know that we certainly did not intend any disrespect. And we found ourselves again in a very difficult procedural position. And that is the real reason that there was no production and compliance up to this point. And as Mr. Heeman stated, I know on behalf of my client, we would really like to resolve this matter in a satisfactory manner, and we are certainly open to that. Thank you.
Okay. You want to ask one? I'll just ask a couple of questions. I'm not going to try and belabor this point, but a couple of things. First of all, it seems to me that the argument that if we're going to proceed on a criminal contempt, that we haven't met the court-based rule process for proceeding on that basis seems to carry a lot of weight, right? The protections are very clear, and the Supreme Court has been very, very clear about the need to engage in full procedural compliance in order to find somebody in criminal contempt. And for the benefit of those who are not privy to the esoteric law of contempt, it's either civil or criminal, and contempt is an authority, but then whether it's civil or criminal, it depends upon a variety of circumstances, including whether or not it's conditional or unconditional in terms of its outcome. And your argument, though, about it expiring at the end of the period of time when the matter was under consideration would only apply at best to a civil contempt and not to criminal, because the deed once done, it remains contempt on the criminal side. So I think your argument has about whether it expired or not is worth considering, but not with respect to if we decide to proceed on a criminal contempt basis. That's number one. Number two, it wouldn't apply if we decided that based upon the information we've received to reopen part of the matter with respect to Ms. Lawton. And the reason I say that is because unlike your clients here, Mr. Jerzyk has in fact complied with the subpoena after the fact. When given notice of this, he then provided information to us, and I had a brief conversation with counsel earlier today because we were dealing with other issues. But I'll just note that in the response by Mr. Jerzyk, he gives us essentially new information that regarding the Lawton matter, Jeff Britt said to me that Shawna Lawton was endorsing Nicholas Mattiello and wanted to do a mailer supporting Mr. Mattiello. That particular phrase was not in the information we had at the time. So it's conceivable that we could consider reopening the Lawton matter based upon the compliance with the subpoena that Mr. Jerzyk made in his response. So it seems to me we have a couple of options here. We could deliberate and proceed and decide to proceed on a criminal contempt as well as civil contempt. Or we could reopen the matter perhaps based upon new information and find out what else is out there in terms of information. Because, I mean, I have to say frankly, the one that keeps coming back to this is Mr. Britt. He seems to be the person that this seems to come back to in a variety of different ways. And certainly information from Ms. Lawton, and certainly information from your client would be helpful in knowing whether or not, to what extent Mr. Britt was the lead operator in terms of the coordinated expenditure of funds. So I'm hearing what you're saying, and I think it's reasonable to suggest that we consider a resolution of this matter without a full-fledged hearing. I think the upshot of what you said is that we should very carefully consider how we're going to proceed as to whether it's criminal or civil, and then send out the appropriate notices. So certainly one thing we may consider doing is continue the matter so that counsel can have a discussion with our counsel relative to ways in which we may be able to reach a resolution on some of these matters.
And we would certainly, I mean, I can speak for Ryan, and I don't
Yeah.
think Joe would disagree. We would welcome that opportunity to
Absolutely.
be able to discuss. We had reached out to Mr. Marcuccio
Yeah.
at some point. He obviously needs your authority to be able to engage in those sort of conversations with us. Because again, it's not there are certain aspects of the subpoena that are very, I think,
Troubling from your perspective.
I was going to say more positively.
Oh.
There are certain parts of the subpoena that are not troubling to us that I think if we can separate some from the others, and maybe we can eventually narrow the issues
Right.
that come before you.
And let me say to you, because I've been accused of not speaking my mind very often.
And before you proceed with that, I do want to note that Mr. Dodd is here. He received notice for the 7 o'clock.
Right, sorry.
And-
We have, yeah, come on up.
Yeah,
Mr.
Mr. Dodd.
Dodd, we have not heard your motion at all. Just as you walked in, Mr. Erickson mentioned for the first time your client's response to the discovery. It was in the context of the other parties and
Not yours, we were
Not-
talking
not
about your
you.
client.
So your matter has not been heard at all yet.
Thank you.
Just your name for the record, please, and
Yes.
you're representing.
Timothy Dodd, counsel for Matthew Jerzyk. And again, if I'm late, I apologize.
You're not late. You
You're
came when
actually
we-
early
You're
from
early
that
from when we
perspective.
asked you to.
Okay.
We started early, and I should apologize for that. But I guess what I was going to say is, look, I'm not trying, I don't think we're trying to to impose some draconian penalty here. What we're trying to do, at least in my mind, is we're trying to establish the board's credibility as an independent agency that has the subpoena power, that has the investigative power, and that we're going to follow that. We're going to do that. And that if we issue an order, we expect it to be followed. It's not individually personal about any one of your clients. It's about the authority of the board. And given the fact that we continue to get campaign finance violation complaints, and we may be doing more vigorous investigations in the future, and we may be issuing more subpoenas. Last year, for the first time, we held somebody in contempt in a case, and we eventually resolved that matter. But we want to proceed forward with people's understanding that when we issue an order, we're serious about it. And look, I've worked with all three of you in one context or another, and I've always been impressed by your abilities, all right? I have nothing but respect for you and the work you did in front of me in court, all right? So I trust you, and I respect your opinions. And I think that if there's a need for a further discussion about how we can resolve this, I'd be willing to make a motion to do that. But I do think we have your client is in a slightly different position.
Would you like to hear from me?
Yeah, absolutely.
Again, I'm sorry I came, I
You
guess,
didn't come late.
I don't want to repeat any of the arguments that were made by anyone for the other parties, but Timothy Dodd for Matthew Jerzyk, and I had filed a motion to dismiss. I do think that Mr. Jerzyk is somewhat differently situated than the others that are before you this evening, in that he's been quite candid that his compliance was late. He's been quite candid that it was late in that he was of the understanding, not from you folks, but just through what was proceeding, that there was a global resolution that was in the works. When a decision was made as to Speaker Mattiello and that the board still had an interest in getting compliance, I think within 24 or 48 hours we complied, because then we realized that you weren't done with this, and our compliance was before any show cause order, before any notification from your legal counsel. we tried to comply post haste when we realized that the settlement made with the Mattiello matter did not necessarily root out, at least in the minds of your board, compliance, so we made it.
Let me just say this. I agree with you. In the sense that, if you don't mind, I want to read some of it into the record, because it seems to me that Mr. Jerzyk did in fact acknowledge the authority of the board and make contrition for it, if you want to use that term. He basically, he said that he had never talked with or corresponded with Shawna Lawton. I had no knowledge of who donated the money. In retrospect, and this is very important that this be on the record, that we are aware of what your client said, because I was very impressed by it. The way this mailing happened was sloppy, and steps should have been taken to ensure that it did not happen. I take responsibility for my part in this and will strive to improve my professional and ethical obligations with the lessons that I've learned from this unfortunate event.
Completely accurate.
I couldn't write it better myself.
It's a good statement.
It's a good statement. And so frankly, although we may want to negotiate in the other cases, I think Mr. Jerzyk's case is ripe for dismissal. And I would move to dismiss Mr. Jerzyk's case.
Do any of the other board members have any questions of this gentleman at this point?
One question. I don't practice law anymore, and I never practiced in court particularly, so forgive my unfamiliarity with a lot of these fine points. What concerns me in this whole situation is what I consider a lack of respect for the board in failing to respond in some way to our subpoena. I heard mention that some of the items were extremely personal. I would have been happy to listen to that argument before us in saying that we are not responding to this part of the subpoena. I do, however, feel very strongly that the behavior of these people was incorrect, and subject to some form of discipline with respect to it, because it's only in that way that we will leave an example for people that when we ask for things, we expect to get them.
Anyone else have anything to add to that?
One last thing. I think that if there's one lesson all your clients need to take out of this, is don't trust the rumor mill at the State House. I mean, frankly, I heard so many rumors about what we were doing, I didn't even recognize us, okay? So, I mean, really, don't trust the rumor mill. I heard it from a guy up there. Isn't really a defense that we're gonna settle, okay?
Understood, Judge.
So what was your motion again?
I'm moving, with respect to Mr. Jerzyk, I was very impressed with his response. I thought that it evidenced actual remorse for his failure to comply, and that he's indicated that he's learned about the importance of responding in a case like this. And so I'm satisfied that that represents to the board an admission that his behavior was not correct and that he's going to correct it in the future. And I'm very satisfied with that. So I'd move to dismiss Mr. Jerzyk's case.
Madam Chair, I'll second that motion.
Moved and seconded to dismiss the contempt proceeding against Mr. Jerzyk. All in favor signify by saying aye.
Aye.
Those opposed, ayes have it.
And Madam Chair, I would move that the other matters we authorize counsel to engage in discussions with the attorneys for the parties to determine if...
Does the board wish to rule on the motions themselves with respect to those two people, denying the motions and then authorizing me to proceed with discussions? Or do you want to keep them pending? It's up to the board.
What's the board's pleasure?
I would move to
Deny the motion.
deny the motion.
Deny the motion to dismiss?
Yes.
And if you did so, I would recommend that you do so to recognize the merits of some of the requests so that In the event that a new contempt proceeding is issued, and it's issued through your criminal authority, you do so with the proper notice in that context.
So that would be part of the motion. Do you have a second to that motion?
I'll second.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed? Ayes have it.
And then perhaps you should, just to be clear, there is a separate motion. So the motions to dismiss were
Denied.
denied. And then with respect to me proceeding, I think you should have a separate motion on
We
that.
authorize legal counsel to engage in discussions with counsel for the parties remaining for the purpose of reaching an appropriate settlement.
Do you have a second?
Second.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed? Ayes have it.
May I just, because I know you now, not everybody is a lawyer involved in this, by denying the motions, and I just want to make sure that our intents are clear in what we have to do, that would trigger us having to do other things in terms of procedurally protecting our interests in the event that we can't achieve a resolution.
Understood.
And so I just want to make sure that as we proceed that, it's not that, oh, well, we're not going to try to resolve it, but we have to do what we have to do in the event that we all can't come to an agreement.
We've been sued so many times recently, we can't even keep track of them.
But there's no, are you suggesting there's a deadline on that?
No, but I think part of our hesitation in filing a declaratory judgment action was to see what the outcome of motions to dismiss were and what the fruits of the settlement negotiation may be. So in the event we do that, we just want the board to understand it's not a
Understood.
rejection of a settlement.
And I'm sure that Mr. Marcuccio will make this a top priority.
Madam Chairman,
Yes.
I'd like the legal counsel to report back to us in the July meeting,
The July 10 meeting?
July 10 meeting, the status of the talks.
So we will put that on the July 10 agenda. Is that okay with you, Mr. Marcuccio?
Of course.
You're gone before you were supposed to be here.
Very good. Thank you, gentlemen.
Thank you.
Thank you all,
Thank you.
commissioners,
Thank you.
for your consideration. Thank you.
Nice to see you all again.
Mr. Judge, thank you.